The next topic I want to cover is the SLAPP statute. And the question is, does the SLAPP statute apply to homeowners associations? The SLAPP statute, as you know, came out about 20 years ago, and it's Code of Civil Procedure section 425.16. When the SLAPP statute first came out, many people, including myself, thought that the SLAPP statute would not apply to homeowners associations because the SLAPP statute deals primarily with freedom of speech. And as we all recall from constitutional law in law school, freedom of speech deals with government action, not private action. So it applies when a government agency or a government official interferes with your speech. It doesn't apply when a private party interferes with your speech. So I didn't think the SLAPP statute applied to homeowners associations, but I was wrong. And there have been several cases in California that have said the SLAPP statute does apply to homeowners association. And the reason is that the courts have held that a homeowners association is like a mini city. And as a mini city, it'll be treated as such, and that's where they tie in the First Amendment issue. The leading case on that is Damon versus Ocean Hills Journalism Club. That's a 2000 case from 2000. Let's take a look at this mini city argument. Suppose you have I could see how it would apply in a case of my association, Woodbridge Village Association, where we have 10,000 units. But what about a 2-unit condominium or a 6-unit condominium or a 10-unit condominium? Is that a mini city? Well, the courts haven't made that distinction yet, and every case that's come down, or most cases that have come down, have said that the SLAPP statute does apply to homeowners association, following the Damon case. I had a case involving a SLAPP statute that just came down. It was a published decision. The Court of Appeal just came down last year. It's kind of an interesting case that I want to share with you. It's called Cabrera versus Alam. And in this case, I represented the association. It's kind of unusual for me because mostly I represent property owners. But in this case, I represented the association, and my client was Alam, who was the president of the association. Cabrera was the former president of the association. To give you some idea about the background, Cabrera and Alam were both real estate agents who worked in the same real estate office, and they both farmed this same association that we're talking about. So this was their farm where they got most of their listings and most of their sales. So that gives you kind of the background. So what happened is it was a board meeting, and at this particular board meeting, this association elects their entire board every year. So every year you could have a whole new board of directors. It's not staggered terms as many other associations are. So at this particular point in time, Cabrera was no longer an owner of a unit in the association. Her unit had sold, but she was still active because she was selling real estate in the association. So she came to the board meeting, and it was the annual election, and Cabrera got up to speak, and she said to the president, my client, and the other board members, "You people have stolen money from the association. You've mishandled association funds, and you don't deserve to be reelected. And I've got my slate of officers here that I think should be on the board, and they would do a much better job than you." Then the president, my client, responds to that and says, "Everything you're saying is wrong. We haven't stolen any money. You haven't presented with any proof of anything. We've managed the money of the association properly, and we've done nothing wrong, and we deserve to be reelected." And my client, not content to leave it at that, went one step further. He said, "In order to prove that you've stolen money, I have the proof right here." He was probably anticipating this was going to happen. And he puts on the board the checks and all the other written documentation to support his claim that when Ms. Cabrera was president of the association, she stole money from the association. So it's all put on a big board behind him that everyone in the audience could see, and he described it in great detail. So after the meeting, you can guess what happened. Cabrera sued Alam for defamation. Oh, I should tell you, the current board was reelected. So that happened. But then after the meeting, Cabrera sued Alam for defamation and other torts, mainly arising out of these statements that Alam made at the meeting. So I look at that and I say, hey, there's a Damon case. So SLAPP statute applies to homeowners associations. So I'm making a SLAPP motion to dismiss Cabrera's lawsuit against Alam. So I feel pretty confident based on the line of cases that are there. And I go before the trial judge, and the trial judge denies my motion. So then I feel very badly, and because I told my client I was going to win this case, and I lost it. So I appealed to the Court of Appeal. And I guess the lesson there is don't ever tell your client you're going to win a case. Anyway, I appealed to the Court of Appeal, and the Court of Appeal reversed. The Court of Appeal ruled that the SLAPP motion should have been granted, that the lawsuit was dismissed, and that I was entitled as a prevailing party to recover attorney's fees, not only for the trial court proceeding, but also for the Court of Appeal proceedings. So, and that is a published decision. The one bad thing that happened after this is about a week after this case, I got a call from another client who wanted to sue the president of the association for something the president said, and I said, I'm sorry, under Cabrera versus Alam, we're not going to succeed. So I couldn't represent that other client.